Hey everyone, this is still Enoch, and I'm still the sensei for commercial transactions, and this is still sale of goods. We're going to be here for a while. So now we are moving on to the aspect of the topic that deals with the implied conditions, implied terms as to description, and the implied condition as to fitness of purpose and merchantable quality. Though I doubt that I would be able to touch on merchantable quality, but it relates to fitness of purpose. That's why I'm mentioning it now. Okay, let's delve in. Section 13 of the Sale of Goods Act gives the implied condition that goods will correspond with the description. That if it is a sale by sample and description, that is not just enough that the goods correspond with the sample, that the goods also have to correspond with the description. I will explain that. We mentioned at the onset in our first module the types of goods, and that there are some called future goods, unascertained goods, and co. So when there is a sale by description, when the buyer has not yet seen the goods or seen what he is buying, but they are described to him, that there is a description given, or maybe there's a sample given that, oh, let us say you want to buy a lot of clothes in bulk, and they give you a sample that this is what the to be like. So yes, there's an implied condition that those goods in bulk have to correspond with that sample, or they have to correspond with that description given. You cannot describe one thing to me and then we have an agreement for me to buy from you, we have a contract of sale, an agreement to sell, and then when the goods arrive, it's something else entirely. No. Section 13 of the Sale of Goods Act frowns against that. It said that a sale by description is when the buyer contracts in reliance on a description, whether expressly or impliedly, especially where he hasn't seen the goods and he relies solely on the description given by the seller. It happens in a situation where there's a sale by description, and it happens where the buyer contracts in reliance on the description given. That means that there must have been a reliance on that description given by the seller, whether the description is express or it is implied, or whether the reliance is express or it's implied. There must have been a reliance on a description that, bros, this is how the thing will be, so and so. Okay, fine, I'm relying on your description, therefore I'm paying you to buy it from you. Especially when you shop from like online vendors or co. That's a very good example of a sale by description. Yeah. In the case of Valley and Whip, in this case, the seller was trying to sell a threshing machine, a tractor, harvesting machine, so something for agricultural, yeah. And so he described it as a 1-year-old machine. But on delivery, it was found that it's not only was it a second-hand machine, that the thing had definitely been used for more than 1 year. So it was held there in that case, Valley and Whip, that the buyer was entitled to reject that transaction as there was a breach of the condition implied by Section 13. Yeah. We mentioned in our types of goods in Module 1 that there are things called future goods, unascertained goods, and these are mostly the categories that fall within a sale by description. Goods that you haven't seen yet physically, goods that you have only gotten a description or a sample of them. A lot of this online transaction and buying we do falls within that, actually. The sale of future and unascertained goods will always be a sale by description, always. Because always be a sale by description, because you are buying based on the description given to you. But there's also, a sale by description could also occur even when the buyer has seen the goods, provided that he relies essentially on the description given. And I will explain. In a kind of scenario now, maybe where you go to a place where they are having an auction or they are selling things, and there's a description written underneath it that, oh, let's say this painting is from the 1800s, painted by Picasso, everything. And then you've seen the work of art. But then when you actually buy it and then you get someone to review it and everything, you discover that, oh, it's from another century entirely, and it was painted by someone else entirely. You relied on the description to buy it, even though you had already seen the goods, even though it was specific that you had already seen it. Aha. So in that kind of scenario, there's still a sale by description, even though the goods are specific. And it was the same thing that happened in the case of Grant versus Australian Knitting Mills Limited. Grant versus Australian Knitting Mills Limited. That situation also applies where you go to a particular shop and you ask for goods of a specific description. Like, oh, I want something of brown, so and so that is able to do this. Even though you've given them, even though when they bring out the goods, you are going to see it and co. You've given them a specific description of what you want. Therefore, if it does not comply with that description, therefore, in that kind of scenario, there's a sale by description, and that implied condition is there that it has to comply with the description. Yeah, the case I mentioned before that is very similar to is that Nicholson and Venn versus Smith Marriott. Nicholson and Venn versus Smith Marriott. In that case, the defendant auctioned off some napkins. You know that some people collect antiquities. So like old napkins from like it was described that the napkins were like from the 17th century, but actually they were from the 18th century. I know that reduces their value a bit. So it was held that even though the buyer had seen the goods before he bought them, it was held that there was still a sale by description because it was relying on the description given in the catalog that, oh, these are 17th century napkins, and so. And therefore it was held that it was a breach of the implied condition as to description, because it's somehow like if that implied condition is there to prevent dishonesty in a manner of speaking, that you can't describe one thing and then bring something else. Like all the things that are happening nowadays, the popular situation of what you ordered versus what you got. That you will see something else in the description, and then when they bring it to you on delivery, you are getting something entirely else. It's a breach as to the implied condition or as to description. Aha. So it is crucial that the goods are sold in reference to the description. It is not just a sale by description just because descriptive words are used in the contract. No. There must be that the goods were sold in reference to the description, that the words identify the kind of goods that you are buying or to be supplied, or their commercial characteristics, the description, everything like that. Even sometimes the courts go as far as to impute a strict interpretation of that condition to include things like width, length, size, inches, and etc. That it must comply with all the description given. And in a situation where it is a sale by both sample and description, Section 13 also implies that it must correspond with both, as seen in the case of Boshali and Allied Commercial Exporters Limited. Boshali versus Allied Commercial Exporters Limited. Usually when we are reporting cases, we use the versus as and, but I'm saying versus so as not to confuse us. That Boshali versus Allied Commercial Exporters Limited. In that case, a sample was given of the clothes to be supplied. And then when the bulk itself arrived, it was discovered that the clothes in the bulk were of inferior quality to that in the sample. So yes, it was held that there was a breach of the implied condition as to description. When this breach occurs, the buyer can either claim the goods with damages, and then claim for damages, or you can just reject the goods outrightly that, oh, this is not what you want, this is not what you asked for, this is not what you were promised. And then the next implied condition we are going to deal with is implied condition as to fitness and merchantable quality. Implied condition as to fitness and merchantable quality. This is dealt with under Section 14. Both of them, Section 14 of the Sale of Goods Act of 1893. I would like us to note that all these sections I'm mentioning, they also have their respective similar sections in the Sale of Goods Law of Lagos State. Although in some places there are some distinctions, but we have not really got into that. So when we get there, we'll tell you the distinctions between the Sale of Goods Law of Lagos State and the Sale of Goods Act that governs the rest. Yeah. So implied condition as to fitness, that one is dealt with specifically in Section 14, Sub 1 of the Sale of Goods Act. The thing is that at common law, before this statute was enacted, an implied condition as to fitness did not exist. It was the duty of the buyer to beware. It was the duty of the buyer to beware of what is buying, that it is fit for the purpose for which I am buying it, that it is of quality. And truth be told, that is like the situation now, even now, in many transactions we do on a daily basis, because people are not aware of their rights and how they apply. Okay. So even though there is consumer protection now to an extent, SOGA still tries to maintain this in the opening paragraph of section 4, because it says that subject to the provisions of this statute and other statutes on the subject, there is no implied warranty / condition as to quality, fitness for any purpose. It says generally that subject to the provisions of this statute of SOGA and other statutes that deal with sale of goods and etc., that there is no implied condition as to quality and fitness for any purpose. But then after that, it goes on to give exceptions, like I said, in sections 14 sub 1 and section 14 sub 2. You know, the law sometimes it tries to first bring one general, then bring an uppercut to cancel out the entire thing. So like that. In that 14.1, it states that where the buyer expressly or by implication makes known to the seller the purpose for which the goods are required, so as to show that it relies on the seller's skill and judgment, and the goods are the type in the course of the seller's business to supply, there is an implied condition that the goods shall be reasonably fit for such purposes. Like I said, I'm going to focus more on fitness of purpose here, because there are elements underneath it before I go to much stable quality, probably in the next module. I'm going to say that again. Section 14 sub 1, that where the buyer expressly or by implication makes known to the seller the purpose for which the goods are required, so as to show that it relies on the seller's skill and judgment, and the goods are the type which is normal in the course of the seller's business to supply, there's an implied condition that the goods shall be reasonably fit for such purposes. Now, for that implied condition as to fitness for purpose, there are elements, there are requirements for it to apply. Because usually the law would not just want to impute a general responsibility on everyone. It expects the buyer to actually beware to an extent, and that's why some of these elements and requirements are there, so as not to open the floodgate of litigation. So one of the first elements, as said in the definition, is that the buyer must inform the seller of the purpose. If you don't inform the seller of the purpose for which you want to use the goods, then he is not liable if the goods are not fit for the purpose for which you want them, because he was not aware. So you must inform the seller of the purpose. But there's an exception to that. Like I said, law, general principle, exception, sometimes exception to the exceptions. Now they put another exception to that one. The exception here is that if the purpose is apparent, then there is no need to inform the seller. Generally, you are required to inform the seller if you want to rely on this section. But if the purpose is apparent, there is no need to inform the seller. The reason why these details are important to take note of them is because usually when we are answering exam questions and they set problem questions, they usually put in facts in the scenario that depicts all of this, that so and so went to buy this and he told him that he needed it for this. Usually it impacts on how you are going to answer the question, it impacts on which direction you are going to answer the problem question. That's why it's important to take note of all these differences. He said that, but if the purpose is apparent, then there is no need. Purpose is apparent in which situation? Like, let's say you are buying food. It's apparent that yes, you want to eat the food. You are not just going to stare at the food and hang the food somewhere for the food to be a piece of art or whatever. Usually, the purpose for which people buy food is to eat it. That was in the case of that chap, Promenier versus Mason. Yeah, in that case. So that if the purpose is apparent, then there is no need to inform the seller. But however, if the goods can be used for several purposes, then it is important to notify the seller which particular purpose you need it for, to be able to rely on this section. And also, if you are going to use it for something that is not the usual usage of that thing, yes. If you are going to use it for a purpose that is not the usual usage of that thing, then yes, you must inform him to be able to rely on this implied condition as to fitness of purpose. It was held in Adeola versus Henry Stevens and Son Limited. This was held in Adeola and Henry Stevens and Sons Limited. In that scenario, in that case, she bought flour. She wanted to use it to bake biscuits, but she didn't inform them. And then she later found that the flour was not suitable for baking biscuits, although it was suitable for making bread and co. And it was held that the seller was not liable, that the buyer could not rely on this implied condition, as the buyer didn't tell him the particular purpose for which it was needed. That's the first element. The seller must be informed. 2, the second element is that you can't rely on this section unless you actually relied on the seller's skill and judgment to buy. That was said in the definition, that you have to actually rely, there must be reliance on the seller's skill and judgment to buy. And this is a question of fact. Most of the time when we say that it's a question of fact, in the sense that just merely telling the person that, oh, this is what I want to use it for, may be sufficient to show that yes, you are actually relying on the seller's skill and judgment. It's a question of fact. It depends on the scenario you are given, it depends on the circumstances. And that it is not necessary, again, it's not necessary for the buyer's reliance to be exclusive on the seller's skill and judgment. It is possible that, that I'm just relying partially on the seller's skill and judgment. That I came with a mind of what I wanted to buy, and then when I heard the seller's pitch and co, I was convinced somewhat to make slight changes to my order and partially relying on the seller's skill and judgment. You can still be brought liable. You can still be liable under this implied condition as to fitness for purpose. And then the third condition, also third requirement for this condition. The first one was that you must inform the seller of the purpose. The second one is that you can't rely on it unless there was actual reliance on the seller's skill and judgment. The third one is that it only applies where the goods are of a description and kind, which it is in the course of the seller's business to supply. That it only applies where the goods are of a description and kind, which is in the course of the business, it is the cause of the seller's business to supply. You can't say you went to buy, let's say you want to go and buy food from someone that maybe deals in electronics, and then complain that the thing was not fit for the purpose for which you bought it, that the food was tasting somehow. You went to buy food from someone that sells electrical appliances. It's not something that they usually do in the usual course of their business, so it won't apply in that kind of scenario. It only applies where the goods you bought are of a description or kind, which it is in the course of the seller's business to supply. As long as it is the kind of goods that the seller sells, yes, it will apply. As long as it is the kind of thing that the seller deals in, it will apply. Yeah, but there are also exceptions to this implied condition as to fitness of purpose. Remember, we said that section 14 sub 1 says that where the buyer expressly or by implication makes known to the seller the purpose for which the goods are required, so as to show that he relies on the seller's skill and judgment, and the goods are the type in the course of the seller's business to supply. There is an implied condition that the goods shall be reasonably fit for such purposes. That was the implied condition. And now the exception. The exception is where an article is sold in its trade name. That's also in that subsection. Where an article or a product is sold in its trade name, like let us say you go to a pharmacy now. You didn't tell the pharmacist what was wrong or anything. You just went there and you asked for Flagyl or Panadol. And you told the person that, oh, I am okay with this, just sell me this. And they give you this. And you didn't rely on anything. You just said that, okay, this is what I want, so and so. Or maybe you go to a plumbing shop, I want 5 inches, wrenches or whatever. You have gone to ask for it under its trade name in such a way as to indicate that you are satisfied that what you are asking for will serve your purpose, and you are not relying on the seller's skill or judgment whether or not what you want to use it for will be that it will be suitable for what you want to use it for. That you're just asking directly for that thing and that thing alone. You're not relying on anybody's skill or judgment. In that kind of scenario, that's an exception to the implied condition as to fitness or purpose. But again, there's an exception to that. Don't worry. It's starting to seem as though I'm saying exception too much. But if you follow the train of thought, it flows. There's the implied condition as to fitness for purpose. The exception to that is when you go and buy something in its trade name. But the exception to that exception is that just the fact that in the contract of sale that the thing is described in its trade name, that does not mean that that's a sale. That does not mean that is a contract by trade name. Let me say that again. Just because when you bought it, it was described maybe in the receipt or in the contract that you had that, oh, it is a so and so, and they went so deep in the description, and they named it out by trade name. That does not mean that it is a contract sold under it, that is a contract of sale under the goods trade name, in the sense that section 14 sub 1 is talking about it. Section 14 sub 1 is talking about sale under trade name in such a way, in an instance that shows that the buyer is not relying on the seller's skill or judgment. That what he's asking for, he knows that what he's asking for is suitable. But it's a different scenario entirely that when you go and ask for something that, oh, get me something that can help me do this and this and this. And then, yes, they've sold it to you. But then in the description they write, when they are giving you the receipt or something, they write the actual name of the thing you are trying to buy. That does not mean that is a transaction under the trade name. Like, okay, let me give a practical example to make it better. If I want to buy a phone with a very good camera, and I go to the offices of where they sell phones, and when they are selling the phone to me, fine, they heard me that I want a phone with a very good camera. Just because they wrote in the receipt that I bought Techno camera something 254 and cool, that does not mean that that's what I went there to ask for. What I asked for was a phone with a very good camera. So if it is not fit for the purpose for which I need it, it is not a bar that I won't be able to rely on this section just because in the receipt they wrote it that, oh, Techno 200 and something, come on, whatever, inches this, inches that. It was held in the case of Baldry and Marshall. In that case, an individual wanted to buy a car. He asked for something that was comfortable and easy to travel in, and the seller suggested a Bugatti to him. And the bros bought it. And in the description they wrote there, they described it, outlined it, the original name of it. But when the guy later discovered that it was not comfortable to travel in such a car for long distances, the court held that the mere fact that it was described under its trade name does not necessarily exclude the condition as to fitness for purpose. So that's it for this module. Implied condition as to, we've gone through the implied condition as to description as governed by section 13, that the goods must correspond with the description, they must correspond with the sample given. We've gone through the implied condition as to the fitness of purpose, fitness for purpose, section 14 sub 1, that it has to be fit for the purpose for which you want to use it, and that there are requirements that the seller has to be aware, and that where it's an article that has many different purposes, you have to tell the person a particular purpose, or when you want to use it for something it is not usually used for, you have to tell the person so that the person will be aware that you can't rely on this unless you are relying on the seller's skill and judgment to buy. Only applies where the goods are of a description and kind which is in the course of this seller's business to supply. Now the other part of this condition, of this implied condition, called the implied condition as to merchantable quality, that is dealt with in section 14 sub 2, will be taken in the next module. So thank you. Please remember to share, remember to subscribe, remember to view, remember to play it as many times as it takes for you to grasp it. Because when you're able to grasp the underlying principles, most of what you need to do, just learn the cases, the case names, and be able to apply the principles to factual scenarios. So please share, subscribe, like, comment, and thank you very much for staying here with us. Still learning with your sensei. Thank you. Goodbye.